I, at any rate, have found it a little bit frustrating to try to get beyond passionate and deeply held political, moral views to get down to a ground of evidence in many of these cases. So the more ground of evidence that you can provide for us to work with, certainly I, but I think other committee members would also be extremely grateful. And Senator Lang, I gather, has concluded his questioning. Senator Baker, followed by Senator Greenrain.
Drug ecstasy, is that influenced in this legislation at all? Affected?
I don't believe it is.
Okay. Let me go to your vetting of the legislation for purposes of the Charter. Now, if you go to paragraph 2 or section 2, where if somebody is found guilty of trafficking in a drug in Schedule 1 or 2, trafficking could be passing somebody something, giving somebody a small amount of something, or selling a small amount of something to somebody. And if that person has been convicted in the previous 10 years of a designated offense, designated substance as defined as being the same type of offense, but it could be a joint of marijuana passing from one person to another. That person will then they'll have a minimum sentence imposed upon them of 1 year and a maximum of life imprisonment. Okay? You follow me so far? You agree so far with what I'm saying?
Well, I follow you, but you posit a situation which I don't believe is likely to arise.
Okay, go ahead.
The fact is that, I mean, I'm not familiar with any prosecution of anyone where a joint was given. At best, there would be a possession charge laid. I honestly have a hard time believing that a prosecutor would even contemplate a trafficking charge in that situation.
I can show you case law on it. I can show you case law, in fact, to every single raid that takes place of trafficking in ecstasy. 1 tablet, 2 tablets. I brought them before this committee and I've read out the cases.
No, that's fine. I was talking about, we were mentioning a marijuana joint. If we're talking about other drugs, perhaps ecstasy or heroin or cocaine, I can't speak to that. I was speaking to the giving of a joint.
Okay, well,
sorry. Just for your information and for the committees, we'll be hearing from the Office of the Public Prosecutor, the Director of Public Prosecutions, next week, and there may be some questioning here.
Yeah. No, I tell you the line of questioning, I just have 2 questions for you. This is the first one. I should get to it. So the first question is this. If you have, the 2 offenses are relatively minor in the amount that's being transferred. It's trafficking, but you're giving it to somebody. You're giving them a pill or 2 or 1. And there was a previous offense. In other words, this is your second offense. When you vet that for purposes of the Charter, the first question I imagine would be is this cruel and unusual punishment? Section 12 of the Charter. And then the second thing you'd consider is, would it be saved by Section 1 of the Charter as a reasonable, and you have the expert behind you, or he was a few moments ago, with the impaired driving, and this has been gone through many times in the courts, various sections of that act. So what you're saying is you've already vetted this, and you've come to or can you tell the committee, because your advice to the minister is supposedly secret, can you tell the committee what the result of that vetting would be in the circumstance that I just gave to you, as I imagine you considered? And was your conclusion that it would be saved by Section 1 and that it wouldn't violate Section 12?
Oh, you must remember, of course, that the way this bill is structured is that it isn't just a simple giving. It's a simple. It would be giving under specific circumstances. The presence of the aggravating factors. If those aggravating factors are not there and it's a giving, then yes, it's an act of trafficking, but there's no minimum penalty involved.
I'm sorry. If you've been convicted of a designated offense...
Okay, so the aggravating factor is a prior conviction then?
Yes.
Okay.
No, but that's what I thought I explained.
Yeah, no, that's fine. We did have our constitutional experts look at this, and they concluded that the regime here would pass constitutional muster.
Pass Section 12 or Section 1? Violate Section 12?
No, I'm afraid I can't speak to the specifics. The net result of their consideration, though, was that it would pass constitutional muster.
Now, my second question is this. Every single police force, absolutely, I think, every single police force that's appeared before this committee on this bill, the RCMP, the Ottawa Police Force, there was one other. They both made a point that under this act, and when you make the penalties, minimum penalties, there's going to be more cases that will be tried. This is their opinion, anyway, of the Crown, of the Organization of Crown Prosecutors and so on. They said this. Well, you're going to have more cases tried. The court's going to be busier, okay? The RCMP and the Ottawa and the Ontario Police Force made a point of saying, look, for us to prosecute one case under the Controlled Drugs and Substances Act that has any complexity to it at all in conspiracy cases, they gave the examples recently of $1.4 million alone just for disclosure. I don't know, did you read that committee report where they singled out a case, the RCMP? $1.4 million. The huge costs associated with disclosure as it relates to the opening of sealed packets and so on, as I am sure you understand. And they say it's an incredible cost. Has the department given any thought to sitting down with the police and trying to figure out a solution to this huge cost of prosecuting a case under the Controlled Drugs and Substances Act that deals with a conspiracy?
There are many occasions when the department is engaged in discussions with the police. The police often bring their concerns to our attention. There are a number of committees that exist. So the issue that you raise about the implications of mandatory minimums perhaps leading to more guilty pleas, longer trials, those have been articulated very well by police and Crown attorneys. And at the end of the day, there's still wide support for the approach of this bill to address the aspects that this bill focuses on.
Well, there's no problem there, but my question to you was quite simple. There's a huge problem that they told this committee of expense. It's a huge, huge expense, $1.4 million on disclosure. In one case, just one case, you know, and they're giving examples. So you have not initiated any discussions with them as far as putting in the legislation, perhaps something that could quell this financial burden that they have placed upon them relating to the prosecution of these cases as it relates to disclosure?
No.
Do you understand my question?
Just to answer the question, no, we didn't. That was not part of our mandate to develop this legislation. So that issue was not considered.
I see. Committee should consider that. This committee.
Thank you, Senator Baker. Senator Wallace has a supplementary.
Yes, thank you, Madam Chair. Just to one of Senator Baker's comments that Senator Baker's comment that someone who could find themselves involved in trafficking, I think you said one joint of marijuana, could somehow find themselves wrapped up in the mandatory minimum provisions of this bill. My understanding is that there is a minimum quantity of marijuana or cannabis that would have to be involved in that trafficking in order for the act to apply, the bill to apply. Is that the case, and if so, what's the minimum?
The trafficking offense with respect to cannabis is split into two. There's I think it's under 3 kilograms and over 3 kilograms, or 3 kilograms and less, and then over 3 kilograms. The minimum penalties apply to both versions of that trafficking offense. So there's no distinction to be made there, providing that the aggravating factors are present, or one of the aggravating factors is present.
Just in terms of the quantity, though, Senator Baker refers to one joint. 3 kilograms, that's quite a quantity.
Madam Chair, on a point of order, the witness understood my question as being related to the designated offense and not the primary offense. And I think the witness understood my question, and I think the witness should have probably taken my side as far as Senator Wallace was concerned.
That is not a point of order, Senator Baker.
I'm just trying to clarify the point you made.
That is not a point of order. It may be fun, but it's not a point of order. Okay? Are you...
Yes, I'll let it. I believe you answered the question that there would be a 3 kilogram minimum for the trafficking charge. That was the point I wanted to.
There are also minimums for production for the purpose of trafficking, and that comes down quite low, 5 pounds, see? Senator Green...
That's why I only refer to that point.
Senator Green-Rain, we must bring some order to our proceedings, colleagues, agreeable though this is. Senator Green-Rain.
Yeah, it's unfortunate. I think Senator Baker's tried to muddy the waters here because designated offense?
Yeah, designated offense.
That's not what we're talking about. We're talking about trafficking more than 3 kilograms of marijuana.
That's in the primary offense.
What?
If the witness can explain that.
Senator Baker. I'm going to ask Senator Green-Rain to address her question to the witnesses.
Could you clarify this for me, please?
Senator Baker.
If I understood correctly, Senator Baker had as the primary offense the giving of a small quantity of cannabis.
Could be cocaine. Could be anything. Could be any offense.
Please let Mr. Saint-Denis complete his answer.
So the primary offense is the giving of a small quantity of a Schedule I drug, or a Schedule II drugs in this case, it doesn't matter. And the individual is convicted, and the Crown can demonstrate that within the last 10 years he's been convicted of a designated substance offense. He therefore is liable to a minimum penalty. And the question was, did we consider this scenario when we did our constitutional evaluation? And the response was yes.
You got your answer.
And the designated offense was a joint of marijuana being passed.
No, we haven't.
Oh, we've got the guy way it's gone, but I think we've been over this ground. Thank you, Senator Lang. Thank you, Senator Baker.
The primary.
Senator Green-Rain.
Okay, I'm just going to... Lost my page now.
You got Senator Baker.